Any mention?
Wait, please, Your Lordship. Your Lordship.
1 second. Next, yes.
Your Lordship, I beg to mention item number 41 on behalf of Miss Colney, Your Lordship, for the corporation. Your Lordship, I'm appearing for the state here, and Miss Colney is appearing for the corporation.
Why? She's not available.
She has some personal difficulty, Your Lordship.
2 weeks. Yes, Mr. Kumar.
Obliged, Your Lordship.
My lord, I beg to mention item number 46, my lord, of daily list, my lord. The conducting counsel, Mr. B. Pathak, has some personal difficulty, my lord. So this matter may be taken after 2 weeks. I have already taken the consent from other side, my lord.
2 weeks, yes.
My lord, keep clear, Your Lordship.
Your Lordship, I beg to mention item number 32. Let it come after 2 weeks, Your Lordship.
Why?
Not required, Your Lordship.
2 weeks, 32.
Obliged.
May I please, Your Lordship, I beg to mention item number 37, Your Lordship. Let this matter be taken after 2 weeks. 37.
30?
7.
Yeah, objection.
Your Lordship.
30?
37. Similar prayer for item 38, Your Lordship. Let this matter be taken after 1 week.
Why? What happened to Mr. Day?
It's on sanction leave, Your Lordship.
Out of station?
Sanction leave.
Okay, sanction leave Mr. Day.
Lordship, I'm for the respondent number 4, 5, 6, and 7.
Yes.
I'm for state respondent, Your Lordship. Obliged, Lordship.
May I please, Your Lordship? I would like to mention item number 39. I pray for 2 weeks' time.
On behalf of Sincon?
Yes, sir.
Yes.
Yes, Your Lordship.
No objection.
Objection is there, but since he's not doing...
He's not here today.
He's here, sir.
Then? What's the matter about it? So heard.
It's regarding it is a small matter, Your Lordship. She is terminated already from service and another has been appointed. So,
When does Sincon? Why make these matters linger honestly?
because she is overaged. So,
Okay, after 1 week.
much obliged.
Yes.
Your Lordship, I pray for item number 28 and 29.
Number?
28, 29.
339?
28, 29.
Where's Mr. Manta?
He's still on leave.
20 and 29? 2 weeks. He's still on sanction leave. Yes, as the county council now is on sanction leave. 20, 29.
Obliged, Your Lordship.
May it please, Your Lordship. Your Lordship, I beg to mention item 43.
Number?
43. Kindly pray for 2 weeks' time, Your Lordship.
Yeah, objection. No. 2 weeks, yes.
You'll be obliged. Please, Your Lordship, I beg to mention item number 45. There's a conducting counsel in this post, Your Lordship. The conducting counsel is in this post, Your Lordship.
Good. Number 45.
Yes, Your Lordship.
45 as a county council in this post, yes. Yes, Mr. Sheikh.
Yes, to see that item number 33, my lord. As per my lordship direction, 25/5/2023, they have initiated to process my pension, lordship, to release my pension. So the only issue whether I am entitled for interest or not. So that can be heard after my lord after 2 weeks, lordship.
Let it be called out. Let it be called out.
Yes, I just received.
Yes.
Supplementary list item number 1.
Your Lordship, I'm praying if this matter may be called up after some time, Your Lordship.
Main list item number 1.
Your Lordship, this item number 1, this was admitted on 13/6, and MCA FA 12. This was also disposed.
Of the order dated 13/6/2003 in this case does not use the expression disposed, which is why it's been listed again today.
But it was disposed in this case. Number 13, no, number 12.
In item number 1, it's MC 12 of 23.
Oh yes, yes.
Similarly, the position.
Take down the number 12, MC FA 12 23. By order dated 13/6/2023, when the instant this application was allowed, due to inadvertence, the matter was disposed of. So accordingly, in view of the earlier order, this case stands disposed of this. And then
similar is the position, Your Lordship, on item number 2.
Miscase
that is miscase 13. This was
13.
also disposed.
Yes, same order. Yes.
Your Lordship, I take liberty to take analogous matter 2, 3 or more there with the same analogous matter. Item 6.
Yes.
Your Lordship, item 6 is the appeal filed by them.
Yes.
Here this appeal was admitted, only the question of maintainability was left open. MCFA 1 of 2022 is filed by the collector for modification of the order dated 28/10/21.
Okay.
Here, Your Lordship, this relates to the court fees. If Your Lordship recall, they have initially filed the appeal with a nominal court fees. Then there was a order on the submission made by my learned friend that the court fees as per Meghalaya
has been paid.
Act should be paid. Then Your Lordship, he filed another application that in view of the one judgment of 1995 Supreme Court, that court fees is required to be paid as per the as per the Central Act, and later on he filed an application that then accordingly that was allowed. Then he filed another application for modification of that order. That is still pending, Your Lordship.
Because that order, that judgment was wrong.
And that judgment was not applicable.
So where does that leave us?
So that may be heard, my lords, at some point.
My
lords, since they have filed several appeals as well and cross appeals.
Only the thing,
after the Section 5 applications are disposed of, they may all be listed together and lordships may consider one of
Your Lordship, only one thing is there. We have already called the records of this in this appeal.
It has not come.
It has come. It has come. Now, if these there are two misapplications which are pending here in the appeal filed by them. One is MC1
and MC4.
Another one is MC4. MC1 is for modification of the order.
Yes.
In whatever way, Your Lordship, in fact, I raised the question of maintainability on the ground that court fees is not
What
paid.
happened to court fees now? You've satisfied the court fees.
Lordship, no, we're willing to pay that. Lordships will have to just modify that earlier order.
Right, then what
about when it came up for hearing, my learned senior had indicated that the maintainability will have to be decided first.
Your Lordship, that because I have raised the question of maintainability in this case, that one of the ground of...
No, what miscase 4 is regarding what?
This miscase, Your Lordship, they want modification of the order.
4?
No, 4 is for amendment.
4 is for amendment. They have filed an amendment petition for amendment of memo of appeal.
Because we have not valued the memo of appeal.
And there are certain amendment, even the
objection to it also.
Yes, Your Lordship, within the course of day, I'll be filing my objection.
To this
So this may be taken next week, and it can be disposed.
Then we'll take the other matter next week also. Lordship, take down that. Then in the main case, this FA3, the number 1. When should we list it?
Here records are received.
When should we list it?
After 1 week.
Yes, FA3, this case.
No, FA3 and FA3 and FA4.
And FA4, yes.
These may be listed along with FA1 of 2022.
Records have since been received. List this matter after a week on so and so. Same order will be passed in item number 1, item number 2, number
6,
and number 6.
And so far this your MC1 and 4 is concerned.
They'll come together.
This will come together within a course of the day. I'll be filing my reply.
And that,
MC4
is also after 1 week, right? So Mr. Vigilan submits that objections to the business application in MC4. In MC4, in main case FA1 2022 lists after 1 week. In this case FA4 2022, Mr. General prays for or submits that the objection to the application will be filed in the course of the day. The list this matter
next week.
Next week.
And item 11 is also analogous.
Number 11.
Item 11.
12 and 13.
Let me finish. 11 is the cross appeal filed by us, and it was filed with a condonation petition. Notice has been served on the condonation petition. And normally we have allowed in all the cases.
No, have you received notice? I appearing on behalf of the 11, 12 and 13.
11, 12 and 13.
Only 11 is a miscase.
Only in 11.
Only 11 is the miscase because here condonation application. This is condonation application.
Item miscase number 2. This marvelous aim.
Same.
Item 11. Huh? Item 11. This is a Miss Cross Appeal. Number 1, 2023.
This is miscase.
Yes, miscase. In this case, Mr. Essen, Ministerial Advocate, has entered appearance today on behalf of the respondents. In view of the earlier orders passed with regard to petition, the delay is condoned and the main appeal is to be taken for consideration. Yes, this case stands disposed of. Stop. And then, registry to diarize and register the main appeal.
Yes. Item 12 and 13 may be listed.
Disposed of, and then that in the main appeal when it gets registered, it is after 1 week together with so and so. Yes.
Item 12 and 13, Your Lordship, here also appeals are admitted, all misapplications are disposed.
Yes. So this after 1 week also together
yes,
with the others.
together. Last item is item 15.
Yes.
Here also notice on condonation is issued.
Same order.
Same order. As that of
As that
Here,
of 11.
we have received notice by yet to enter appearance. Kindly give me a week's time. We haven't received the wakalat numbers yet.
Okay. 15, miscase FA 14 or 2023. Stop. Mr. Essen submits that they will be entering appearance on behalf of the respondents. This after 1 week together with other connected appeals.
here delay may be condoned, Your Lordship.
No, let him enter appearance formally.
Right, sir. No problem.
Yes.
Highly.
Kumar to below 1 page, 52, 53, another below.
Item number 3.
Your Lordship.
Yes, start.
Your Lordship, the conducting counsel, Madam N.G. Sheila, is on legs before the other court. So if this
Who's
matter,
conducting this matter?
Lordship,
Who is the counsel?
Madam N.G. Sheila, Lordship.
After some time?
Lordship, if this matter can come up on the 11th, that was my instruction.
Why?
Lordship, that was my instruction.
Because
Lordship, she had requested if this matter can be taken up on the 11th.
who requested?
Madam N.G. Shila, Lordship.
It'll be on legs till 11th.
No, Lordship, like,
That's your initial submission.
Lordship.
If you ask for adjournment, you ask for still adjournment. Don't say that she's on legs and before another court and it will be fixed on 11th. Just after 2 weeks. Yes.
Obliged, Lordship.
On the prayer of the petitioner.
Item number 4.
Can't take court for granted. Yes.
Yet to file here.
Yes, Mr. P.T.
Because,
Samar.
in this case, I need some time because some instruction is required.
How many times have you taken, Mr. Debnad?
I have taken lots of time. In between, there was some from the ministry. Some
Lots of time.
So, in this case, Your Lordship, in this 1-on-2, petitioner, I came to know most of them has taken the compensation.
That is not true, my lord.
So
I'll be answering because.
But you have not seen it. You have not seen it.
They have not. None of the petitioner have taken the money.
How do you know that?
I have the document. So they said that is they are making a wrong submission before this court. Let them file in the affidavit in detail. I will reply to the thing, because now it is verbally saying
information. Because I just sought some information. Who are the person has already taken the compensation
from the list of the petitioners? How many petitioners are there?
193. Let him put in affidavit. He says only got the information. How can we just believe? Let him identify. Let him specifically.
How can he just believe, or how can you believe?
Yes, that is I can't believe. Your Lordship. Yes, because he's making just by person. Let him put it in the affidavit on record, so that I also will go through. Because he's just making a verbal submission, just wasting the time of the court. This is not the time for hearing also. These things you can make a submission.
Thank you so much for being conscious about the time of the court. Yes. How much time?
2 weeks.
Mr. Ardana, appearing for respondent number 9, submits that he has sought details of the writ petitioners who have been stated to have. He has sought details of the police who have been stated to have received some compensation and stuff. He prays him allowed further 3 weeks' time to bring affidavit on record. Yes, after 3 weeks.
Lords, 4 and 5 are connected. In 4, we've already filed an affidavit. As far as 5 is concerned, it's already drawn up and sent to the department. We're seeking 2 weeks' time to file it.
The list together. Yes. Number 5, we are appearing there also?
Lordship.
Number 5, to number SN, please, for 1 second. And there's allowed 1 week's time to file affidavit. Yes, he appearing for respondent number? In number 5. In which matter? Yeah. Have you filed the affidavits there? No. I don't know. Okay, so, Absha, first number 3 is over. Yes, that's number 3, right? Yours number 4. Okay, I can file number 5. That's not hurry. We have lots of time. Yes. Okay. Number.
I'm number 8. In 4, I'm the respondent number 8.
Number. Number 4. I have number 4. Okay, one at a time. I didn't know they connected matters. Wait. I thought the details of the petitioners who have stated to have received compensation. So he prays the same by way of he prays the email to bring the same. Or he submits that he will place the same on record by affidavit. Okay, only 3 weeks time is granted. Yes, that's time number 4. Now number 4, and then yes. Who are you? Oh, that's I think it must be earlier recorded also.
Is this recorded?
In this absent how you're finding affidavit. Similar prayers made MSS from Thao, or prayers made from Thao for affidavit on behalf of the respondent number 8. You already filed here, Mr.
We have on behalf of 1 to 4.
Yes. What's your name? MSF Lambrang for respondent number 10 submits the no affidavit before coming from their side. And you? Then not necessary. Yes. This after 3 weeks, yes. Then number 5. Yes, so number 5 is opinion number 5.
for respondent number 6.
You're for number 6, yes.
So I need some time.
You file affidavit? No. You. That one you not file here also.
I didn't
file affidavit here, no.
I'll be filing it.
You won't be filing.
I'll be filing.
You filed here.
Releases 2 weeks time. We've already sent it to the department.
That Mr. Devnath prays for further time to file affidavit on behalf of number 6, similar prayer made by S. Rumthau. Stop. Mr. S.N. submits that the affidavit will be filed within a week on behalf of the respondents, 214. Accordingly, this is a matter of 3 weeks for affidavits by the aforestated respondents. Yes. Next. That's it.
Item 7.
6 was for the time. Yes.
Your Lordship, the respondents 4 to 6, they haven't filed the affidavit yet. Even respondent 1, they have not filed additional affidavit.
What about 4 to 6?
Your Lordship, we're representing respondents 4 to 6. Your Lordship, we require...
Catch your breath.
Your Lordship, we require 3 weeks time, Your Lordship, to file our...
Why 3 weeks time?
Your Lordship, actually, the senior conducting counsel, Sir K.C. Contempt, Your Lordship, he's a little bit unavailable as of right now.
Wait, where is he gone? He's gone out of town.
Out of station.
Your Lordship, they have been seeking time from April, Your Lordship, as matter certain.
This matter is a dead duck anyway. They'll seek time. When can you file the affidavit? Within
3 weeks, Your Lordship.
3 weeks.
3 weeks.
It's
Yeah,
noted that
2 weeks.
repeated time has been sought for filing affidavits by the respondents 4, 5, and 6.
And one
not 4,
also.
5, and 6. Number 1's file, you want to improve the affidavit.
Yes, Your Lordship.
Calmly. Though an affidavit filed on an earlier occasion, behalf of respondent number 1, this court, on the prayer of the newly engaged counsel, had allowed for filing of an additional affidavit. Stop. Today, MSS Rumthau seeks further time to file the said affidavit. Stop. Similar prayers made on behalf of the respondent 4 to 6 who have been served notice on. When will they serve?
April, in the month of April. Your
No,
Lordship.
the 4, 5, and 6.
Yes, Your Lordship.
Perhaps time.
April, Lordship.
Was been served in April. Stop. Accordingly, this is a matter of 3 weeks for affidavit by said respondent. Yes.
Apply, Your Lordship.
Item number 8.
1 second.
8, 9.
Please, Your Lordship.
Are both these in the earlier matter? Are both these applicants? They are practicing advocates. Where's that lady? Anyways, okay.
8.
Please, Your Lordship. Item number 8 and 9 relate to that standard table of rent issued by the cantonment authorities. The union was left to file their affidavit. We received their affidavit on the 8th of June 23. Union of India. We were required to file a rejoinder. But in the meantime, there's some development. The central government has taken a decision, and there is a proposal to transfer all civil areas under the cantonments to the state government.
Excision means cutting.
Cutting off. I was also not familiar with this word. Kindly see the next letter, 2nd of June 23, where the president of the Petitioner Association has been invited to participate in the discussions. In my understanding, if this excision takes place, then our challenge to the rules, or even the rules, will lose force. Our case will be rendered infructuous.
No, I read somewhere. I've seen also
It was in yesterday's papers as well.
Cantonments, yes.
It was in yesterday's paper. So this is pan-India movement. for transfer of all civil areas. So if this does happen in all these
transfer,
cases,
it's like they're going to cut off civil areas and have only the core military areas to be under cantonment.
So the management will go to the deputy commissioner.
Yes, Mr. DNO submits it. While submit the plans complete the conditions matter for
Please,
hearing.
Your Lordship, we have not received the rejoinder.
That you fix up with him?
I will supply you.
You supply a copy?
Yes, sir. Obliged.
Not sure.
16, 16, 16.
That's very important. Yes, Mr. Sheikh.
Yes, Lordship. Here
15 appearing.
16, 1-6,
16, my
Lordship.
lord. It's a contempt matter.
1-6.
Oh, 16 yes.
Here, Lordship, after filing the petition, Lordship, I received a call from the law officer, Lordship, they are ready to comply the order on or before the next date, Lordship, that is today, Lordship. It's in the process of complying, Lordship.
The process dispersing, my lord.
No, we close the contempt. Yes, Mr. S.A. Sheikh submits that the order is in the process of being complied. As such, the contempt may be closed. According contempt stands closed and disposed of.
Highly obliged, Judge.
Highly obliged.
Is a very important file in the file. If anybody make command for file for the explanation.
Fourteen.
We have already filed the affidavit on behalf of respondent number 2, my lord. So far as 1 is concerned, my lord, we have served the copy, my lord. We are in the process of filing the affidavit on his
Your
behalf.
Lordship, we've just received it.
Both for 1 and 2?
1 and 2 we've already received.
Yes, Mr. Estapa submits that the affidavit on behalf of number 2 has been filed, and behalf of number 1 has been filed in the course of the day. This is matter after 2 weeks. Yes.
17.
This contempt may be closed, my lord. We have received the payment, my lord.
Mr. M. Second submits that the order has been complied. Please the matter be closed accordingly. Next, according contempt stands closed and disposed of.
18.
Wait, please, Lord.
Lordship, I was supposed to file an affidavit on the last occasion. This order was passed. I could not find your Lordship through in that detailed mistake. And I have sought some instruction from District Council also. I may be permitted 2 weeks' time to file the affidavits as to bring on record. A letter dated.
Mr. Kanta, you're not wearing a coat also.
Yes, Your Lordship.
You're not even wearing a coat. You're appearing in court.
Your Lordship.
Sorry to point it out.
Your Lordship.
What document are we supposed to bring in report?
The letter dated
2nd September 2021.
September.
It's here. Okay. We will. You want to file affidavit? What do you want to do? You want to file
So we want to respond to the.
Yes, Your Lordship.
See, since you have not filed affidavit this regarding the letter, we will take it on record and let them answer it.
Yes, Your Lordship. This is what I submitted.
Also, the state respondents were supposed to file their affidavit, Lordship. They had-
Lordship, we need some more time to file the
Why? When was this matter filed?
This year only, Lordship. 23.
Yes, this year. Which date?
Lordship, the matter was moved on 21/2/23, Lordship.
21/2. Now we are how many months? 5 months down the road. Why you can't file affidavit? Yeah, take down first. Mr. Vijay Kanta submits that due to some unavoidable circumstances, the letter dated 2nd September 2021, which had been produced before this could not be filed with affidavit. So, like taking considering submission, the letter is produced is taken on record by this court, is taken on board and made part of the record stuff. Do you have a copy of the letter?
Lordship, we have.
Yes, Mr. Chanda appearing for the writ petitioner prays aloud to. You're going to find affidavit.
Lordship, we'll file a response to it.
Next one, Mr. S. Khan. Yeah, S. Khan.
E.R. Khan.
E.R. Khan, sorry. On behalf of the state respondent, prays that further time be given for affidavit by the state respondent. In this matter, after 2 weeks for the affidavit by the petitioner and by the state respondents. Yes.
Much obliged.
19.
May I please, Your Lordship? Your Lordship, I already paid 2 weeks' time, Your Lordship, to file rejoinder affidavit.
Already, how many times have you taken?
Second time, Your Lordship.
MS Energy pays for allowed for the 2 weeks time file rejoinder.
20.
May it please, Your Lordship, we have already filed a rejoinder, Your Lordship. The matter may be posted for hearing after 1 week, Your Lordship.
You are appealing for?
Your Lordship, for all the respondents.
All the respondents. MS Shalom submits that the rejoinder has been filed. There is a matter be listed for hearing after 1 week. This is a matter for 1 week for hearing.
21.
Please, Your Lordship. Your Lordship, in this case, we are yet to receive instruction, Your Lordship. So, please, for 2 weeks' time.
2 weeks for the time granted the response to file affidavit.
Similar prayer for
prayed.
item 22, Your Lordship.
As prayed further 2 weeks time granted affidavits.
So much.
23.
Please, Your Lordship. I have already taken step, Your Lordship, and respondent 4 and 5.
Yes, MPSC. What about 4?
Who is the CM of Maine?
Who's been over 4? Five, or you're the private respondent. Ms. Ardata has entered appearance today on behalf of respondent number 5. None appears on behalf of respondent number 4. How much time do you require if you want to file affidavit? Mr. Tosha from Ms. Ardata has entered appearance today on behalf of the respondent number 5 and prays for 2 weeks time to file affidavit system. What about state? 2 weeks time. Similar prayers made by
1, 2, 3.
1, 2, 3, and what about you?
We're just a performer respondents.
Yes, 1, 2, 3. So list of 2 weeks.
24.
May I please, Your Lordship? In this case, Your Lordship, I need some more time because I have not received any instruction from the government. We have already taken step for respondent number 5, Your Lordship.
Once again. This case, why third notification?
Your Lordship, yesterday night they called me and said asking for requesting Your Lordship to granting some time.
Who called you last night?
Your Lordship from the office, one project director.
That's not sufficient. Anyway, MS submits
They're
that
busy with other cases.
he has not been received instructions as yet, and prays that further time be granted. MS Raji submits that steps have been taken to respond number 5. Accordingly, this is matter for 2 weeks for affidavit by the respondent 1 to 4 and for service report on respondent number 5.
Much obliged.
25.
So 25 is a somewhat connected matter and may be granted some time. 2 weeks time to file the affidavit.
In this matter also we have already text up for respondent number 5.
2 weeks time granted.
26.
Lordship, we may be allowed further time to file an affidavit in this case on behalf of the respondents, state respondents.
MS Tiang EAG with so-and-so prays for further 2 weeks time to file affidavit just thereafter and so-and-so.
Hearing 27.
May it please your Lordship. Lordship, this is a civil division petition, Lordship. Here the respondent as a plaintiff has instituted a suit before the learned court at Tura, Lordship. Way back in 2009, Lordship. Claiming the suit for declaring that she is the legally wedded wife of my husband. And I am, and further short declaration that I am not the wife of late Gyani Ram, Lordship. My husband was working in the PW department, Lordship, and after the death of my husband, I was receiving the pension, Lordship.
Yes.
Then she filed a suit for seeking two declaration as well as for injunction, Lordship.
Yes.
Then till 2009 to 2016, Lordship, the matter was pending before the trial court at Tura for taking steps, because the petitioner hearing after the death of her husband started to reside at her permanent residence at UP, Lordship. So that is why in between several times notice were issued. In both the address, Lordship, the notice was not served.
To you?
To me. Then, Lordship, in the meantime, in 2016, Lordship, then separation was taken place and Ampati was created, a new district, Lordship. And after the creation of new district, Lordship, then case was transferred to Ampati, Lordship. Then, Lordship, I have in page 7, Lordship, the sequence of the case I have mentioned in para 8 and 9 of my petition, Lordship, that is at page 7.
Yes.
Then after the case was transferred from Tura to Ampati, Lordship, the case was listed on 7/11/2017, Lordship, and on that day I have entered my appearance through the council, Lordship, and I have received the copy of the plain from the court, Lordship, and the matter subsequently fixed on 28/11/2017 for appearance of other defendants.
Yes.
1, 2, 3 is the government and 4 is myself, Lordship.
Okay.
Then on 28/11/2017, Lordship, the other defendant entered appearance and the case again fixed on 6/2/2018 for filing of written statement, Lordship. Because Lordship is well aware that January and some part of December and some part of January is closed for winter vacation.
Yes.
Then, Lordship, then the plaintiff counsel, Lordship, on 6 February 2018, the plaintiff counsel entered appearance and filed his bagalatnama, and the matter was refixed on 26/2/2018 for filing the written statement. On 26, the the court was on leave, Lordship. That is why the matter could not be taken on 26/2/2018, and the matter was listed on 28/2/2018, Lordship, on call. And on the very day itself, Lordship, I have filed my written statement, Lordship.
You appeared on 28/2 and filed the statement.
Yes, Lordship.
Okay, then.
I have filed my written statement. Now, so far as other respondent is concerned, defendant 1, 2, 3, the government defendant, Lordship, they sought for time, and the plaintiff had objected.
Yes.
Objected for giving time for filing the written statement. Then subsequently, Lordship, what happened? Then the matter was fixed for 5/3/2018 for filing of written statement by the other defendants, Lordship. Now, Lordship, here since the plaintiff has raised objection, why I am saying that she has not raised any objection with regard to the filing of my written statement, Lordship. She has raised objection with regard to the filing of the written statement, enlargement of time for filing of written statement by the other defendant, Lordship. On 27/3/2018, there was a hearing whether the written statement, whether can be taken on board or not. Then after hearing, Lordship, my written, that has passed the impugn order, and the written statement was.
But by your submission, you said that you had filed a statement on 28th of February.
Yes, Lordship.
2018.
Yes, Lordship.
And then the other defendants sought more time.
Yes, Lordship.
And it was fixed on 5th of March.
Yes.
2018. And 5th of March, they filed the statements. Correct. And then an objection was filed by the plaintiff against the acceptance of statements of the other defendants. Is that your case?
Yes, Lordship.
And not against you, actually.
Not against me, Lordship.
But the impugn order also has rejected the statement.
Yes, Lordship. Lordship. Then subsequently, Lordship, what happened? Although the counsel which I have engaged, he was kept and appearing, but he was not informed about that the incident that had happened, that rejecting my written statement.
How will he be informed? It will be there in the order sheet of the record.
No, the counsel. I am talking of the counsel, Lordship. The counsel was not intimated me about the incident that my written statement has been.
Didn't intimate you?
Yes, Lordship.
I mean the
petitioner,
defendant number 4.
Yes, Lordship.
Okay.
Then I put up. Then I have engaged a new counsel. Then I put up application for recalling that order. Then that application has also been rejected by passing the impugn order, Lordship.
Yes.
Here, Lordship, if Lordship kindly see,
yes,
from 7/11/2027 till the date of my filing of my written statement, although there was a winter vacation, Lordship, even without excluding that period also, there has been a delay of 23 days, Lordship.
One second. Yes. What are we saying?
Here, Lordship, I entered through my counsel on 7/11/2017.
Okay, let's go through the date.
Yes, Lordship.
Okay, so you through counsel, you
7/11.
Okay, 7/11/2017. You entered appearance when the case was transferred to newly created district. Okay. Petitioner. Okay, appeared. Right.
Then, Lordship, the matter was fixed on 28/11/2017.
Yes. And it's fixed for
filing of WS, Lordship.
Yes.
So far as Lordship,
and date we fixed on
7/11/2027, the matter was fixed for appearance of defendant number 1, 2, 3 and states, Lordship.
Have come.
He has provided the entire order sheet, Lordship, the respondent.
Records not called for?
No, Lordship.
don't suppose, Manoj, because I had taken the liberty to file the order sheet with the permission of the court.
Is it done record?
Order sheet. We had to supply to the court. I've supplied to him.
I have received, Lordship.
Let us see the order sheet. Is the entire order sheet of the entire?
Yes, Lordship.
Not the entire, till a particular date. My friend's contention is that he entered appearance on 7/11/2017.
No, we have to call
after the
for
matter went to
we have to call for the records. Is the matter proceeding now?
No. I have that order sheet as well. The matter is fixed for cross-examination of the plaintiff's witnesses. They don't appear at all. I have the entire order sheet for that.
But there is an stay, Lordship.
No, that stay has already expired.
Is it? I mean, there's no stay in the proceedings, correct?
On the date of motion, a stay was granted. That stay was only for a period till the next date.
What
That has
happened
already
after
expired.
that? The stay was extended. Is a suit
well,
proceeding?
It's suit is proceeding, but they don't participate. It's fixed for cross-examination of the plaintiff's witnesses, but they've not been appearing. So we've been pressing the court to...
The written statements have been considered. It's proceeding from the written statements have been rejected,
Yes,
right?
Lordship.
And so it's proceeding from that.
Yes. If Lordships will kindly have page 3.
Of the
My
order sheet.
friend's case is that he entered appearance in 2017 after this case was transferred to Ampati. Can you see the first order, 31/7/2009 at page 3?
Yes.
Plaintiff present and represented, defendant number 2 and 4 represented by their lawyer.
Yes.
It speaks otherwise. Now, even in his petition, he does not say that he did not receive notice in 2009. He simply says the case did not proceed in Tura and it was subsequently transferred to
His
Ampati.
submission is a very good submission he has made. He said that he entered appearance, but then he shifted residence to UP.
No, that's much later. He does not say that in 2009 he received notice. He says he entered appearance in 2017 after the matter started, after the proceedings
Yes.
resumed before the Ampati court. But when it was originally filed in Tura, he makes no statement whether he received notice or not. Now, this particular order of 2009 indicates that he entered appearance.
Then we need the records.
Lordship.
It appears that but then the suit will be stayed then.
Lordship.
The suit will be stayed then.
I'll just point out the direction of the Honorable Supreme Court is that any stay order, the life of that would be only 6 months and automatically that would cease. So in this case, no prayer was made by them for continuation of the order of stay.
Is that correct? When was this case filed?
Here, that stay order was granted 15/10 to 19, Lordship.
15/10/2019?
19, Lordship.
Yes, Lord.
And it's been stuck here since?
Yes, Lordship. For the proceeding in the trial court are state, Lordship.
1 second. 15?
10, 2019, Lordship.
Oh. Yes. Yes, after that didn't continue.
It did not continue. And thereafter, my learned friend has been seeking adjournments in this matter. And in the trial
but
court,
the
they
thing is
don't
that
appear.
see, this order is not till the next date.
Not that, that's why.
No, my lords, even if it is not till the next date, as per the direction of the Honorable Supreme Court,
Whatever it
based
is,
on next, it's only for 6 months.
Whatever it is.
So it's supposed to automatically expire at the expiry of 6 months.
We'll have to call with the records.
Since there is no mention that till further,
If you,
that is why I have not made any prayer.
if you,
he should have filed
you submit
application.
for the court that the initial date of appearance 2009 should be taken into account in deciding the matter. We need the records.
Lordship, I have no difficulty.
Because we have to go from records. I mean,
I was reading his.
all records. It's all in records. It's not a
Absolutely.
question of pleadings before.
Absolutely.
Or like whatever submissions you make before this court.
Absolutely.
Yes, in the course of hearing, it appears that the records of what's the statute number? TS number 5 of 2009, which is pending in the court of
Assistant Deputy Commissioner
Ampati is necessary. According to the step registry to requisition the records. this immediately on receipt. Why small matter statements get pending for so long? Why?
Lordship, because I was not informed. I didn't get the notice, Lordship. Though, although my friend is showing that I have entered appearance through the lawyer, Lordship, on the earlier occasion, Lordship. I have to take instruction on that issue also. Who have appeared on my behalf, Lordship.
It would be also material, my lords, in
It
2000.
appears, you take this back. It appears so.
It
that you
appears.
entered on 27/5/2009 something.
Lordship. And also, if they have the P5 form for the date of appearance in 2017, that will also be relevant. Because he says he received it in 2017. We'll have to just examine the P5 form, whether that statement is true.
See, usually notice goes again after, if it's been transferred to the court.
So that too also I have received only the notice, not the plain Lordship. That is on record. On that day when I entered
But
my
look at the time lapse, Mr. Sheikh. If you had entered appearance on 2009, then the suit didn't proceed anyway.
Did not proceed. I'm not really sure the reasons why.
That was what, 9 to 16. That means it was
issuance of
suspended
notice.
animation.
No,
No,
there are
it
dates.
is impossible. Now that is 7 years.
But I have shown that's a very thick order sheet. That entire order sheet is for 2009, 10, 11 and 12. So they did appear in 2009 and thereafter they stopped appearing. Notice
Well
was
and good,
recent.
but what happened between 2009 and 2016? The suit just was in limbo.
Keep on notice was issued, Lordship.
And you went off to Bihar.
Bihar,
Uttar Pradesh. And you forgot about the case.
I have to think.
And when did you come back to Garo Hills?
So I am still there, Lordship.
Still where?
UP,
In
Lordship.
UP.
UP, Lordship.
So
they
who's your
claim-
counsel? Anyway.
So they claim in
let's leave that
2017.
for another date. Huh?
So they claim in 2017 they
So
received
now, and then
notice.
you say that you never did appearance before. The first time you was after the separation, 2017 entered appearance.
So
and received copy of the plaint.
That part I have to take instruction, Lordship, whether because it's through lawyer, Lordship, then I have to take
It's a
instruction.
very serious
Yes,
matter.
Lordship.
That means you're committing perjury if you say that you never appeared.
And moreover, even I'll take instruction on that issue, Lordship, on that facts, Lordship.
Yes.
Item 30.
Hello,
30, my lord, I'm praying for some time and requesting for another date, my lord. This is that matter, my lord, where they seek to cancel our lease agreement and resume the property at Forest Colony, my lord.
Oh yes, interesting matter. You ready?
But what we can do, well, senior's ready.
Who's the senior?
Mr. Andy Shulai.
When? Where's Mr. Paul? This is a sensitive matter, so we want to argue himself.
He's there again out of station, my lord. He'll be joining next week. By weekend he'll be here again.
This on the request of the counsel for the petitioner. This is matter.
Next week, my lord, or after 2 weeks.
After 2 weeks.
31. 31.
31 is same order, my lord. Similar one.
33. 33.
What were you saying, Mr. Sheikh, this matter?
My Lordship has directed to release the, by order dated 25/5/2023, directed to release my terminal benefits, like Lordship. So in pursuance to that order, my Lord, I have received some communication.
What communication have you received?
May I please, Lordship? Lordship, we have released the GPO,
The GPO?
The gratuity, the pension, and the leave encashment, Lordship. May I please?
How long is the delay?
Delay going to be 10, Lordship.
10 years?
10 years, Lordship. And there is a little discrepancy because I have to take, I had a talk with my client because the pension, as per the letter, they're showing the 10,000, Lordship.
Yes.
But it cannot be 10,000, it ought to have been more than that, Lordship.
Yes, pursuant to the order date 25/5/2023, it appears that the respondents have since processed the release of the terminal benefits of the writ petitioner. Stop. Mr. H. Karanlang has produced certain communications indicating this fact. That since, yes sir, how is this? Why is it dated 30th November on top and the 4th July 2023 below? See, look at this, Mr. Karuna. This one you could office order.
Lordship.
What is wrong with this?
Well, I've got to seek instructions regarding this, Lordship.
What seek instructions?
Lordship, yes, Lordship, I've seen the discrepancy, Lordship, but then I have received these documents yesterday only, Lordship. I think it's
very strange.
Lordship, this is office order.
The memo number and the letter number are also not this.
Lordship, the copy 2 will be 4th July, but the order is a different order number, Lordship. This is on top, Lordship, is a number E1662.
It is submitted that. The respondents, yes. Stop. Mr. Karan's produced some documents today to substantiate this fact, which, however, he seeks time to take instructions as to the discrepancy in the dates that have appeared therein. Stop. Next, Madam S.A. Sheikh also praising Lord to take instructions with regard to the
amount of pension.
Yes. Yes, Dr. Sumik.
Hello, Lord.
Hello.
It's in the hurry to comply. There's a 4th July and they're free to some. Anyway.
34.
My lord, the writ petitioner was removed by the Women College management without issuing show cause notice. The two grounds we have taken primarily, my lord, the removal of the petitioner is in violation of the principle of natural justice. Number two, my lord, there is no reasonable ground available for removing the writ petitioner from the service. My lord. He was holding the post of assistant professor in the computer application department. What happened? But he was appointed initially in 2011 along with others. Immediately, there was no selection process, but it was a temporary appointment. After
One second. So he was regularized?
My lord.
He was just inducted?
My lord.
Okay.
He was, my lord, after 2011, he underwent for the probation and his service was regularized according to me, though the other side denied, in 2013. And college pay scale, regular pay scale also granted to me in 2016 onwards. Now, may I take Lord's attention to Annexure 1, page number 23.
Where's the appointment order?
My lord, there is no appointment order issued to me. Several times, my lord, we asked for their copy to be served to me. They didn't serve, my lord. To others, my lord, similarly situated, they have given copy to the other parties, other teachers. But to me, my lord, they did not serve me. I'll come to that one, why they were not willing to serve a copy to me. But page number 23, even my grievance along with others were also recognized by the staff. Therefore, there was a meeting, staff council meeting, page number 23. And even my case was pointed out in the middle, Mr. Ajit Paul, in the below portion, at the bottom. Department of Computer Application to be brought against college pay scale. Now, this was the my notes of the GP, my lord, is a governing body, my lord.
Where is it? This is a staff council meeting.
But it is a governing body and stands corrected, madam. It is a resolution of the
23.
page number 23.
Okay.
Madam. Briefing of GP resolution adoption on such and such. Now, this one, my lord, what happened is this is the adoption of the by the staff council, reflecting the decision taken by the governing body.
Okay.
Governing body. Now, thereafter, what happened?
So that you brought in a college pay scale.
I was brought in college pay scale.
This
Now,
is dated when this GB meeting 8 June.
Right. 8 June 2013 on the top of this day.
Yes.
So I was
and when you brought under the college pay regular
college
pay
pay
scale from 2013 itself.
Yes, itself. Right.
From June.
From June, madam.
Okay.
From 8 June 2013. And the page number 25 or so. But at that time, my lord, the designation of the boss was a lecturer. Page number 25 is an identity card, my lord. It shows a lecturer, computer science. And my lord, may I take lordship attention to page number 27. Even the principal of the college acknowledged that I am holding a lecturer post in the department. Since such a full-time lecturer in the Department of Computer Science since such and such and such, and currently drawing such and such. It's a regular pay scale. It's acknowledged by the principal also. Now, thereafter, my lord, page number, the next page, page number 28. My lord, consolidated pay statement also. My lord, Mr. Ajit Paul, this 2016. Even I am also part of the contributing by the Provident Fund. Normally, my lord, temporary employees are not allowed to participate in the Provident Fund scheme. He was allowed because he was regularized. Thereafter, the next page, page 29 also, may just 2018 statement reflect the same. 30 also, page 30 also. Page 30 also. That shows the matter I want to bring home that he was a regular teacher.
For all practical purposes was a regular employee.
Regular.
That is your stand. Okay.
Yes, my lord.
Yes.
And my lord, page number 31.
Yes.
Staff council meeting again. My lord. The staff has recognized Mr. Ajit Paul number 2. Appointment letter has not issued till date. So this was also brought.
This is in 2016. You started working from when?
My lord.
You started working from
2011, but
okay.
Brought within the regular scheme
13 years.
in 2013. And thereafter, my lord, page number 32, there was a letter signed by the 27 staffs collectively apprising the grievance of the petitioner also. That his appointment letter is not yet issued, requested for issuance of that appointment letter.
Yes.
In my take, my lord, page number 35, he personally requested for issuance of formal appointment letter. It is quite uncertain for him without appointment letter. For practical purposes, he was considered as a regular teacher. My lord, nothing was happened. And thereafter, my lord, page number 37, in 2017, my lord, as per the UGC qualification guidelines, the designation of lecturer was no more, but converted into assistant professor. This is a notification, my lord.
Yes.
As per governing body resolution 2017, all lecturers in the college with UGC qualifications are designated as assistant professor with immediate effect. Accordingly, the petitioner also, my lord, it was converted into the same thing, my lord. Now, page number 39, it is important document, my lord. I just read slowly. Statement of my lord, fixation of pay scale, my lord. Name of the employee is Mr. Ajit Paul. Now, designation, well, assistant professor in computer science, the computer application. Now, date of joining in regular pay scale, 8 June 2013. So this was issued at the bottom, my lord, 1st September 2018. So, my lord, my service was treated. That is a permanent teacher in holding the college sanction post.
Yes.
Now, thereafter, my lord, may I take page number 40, my lord. The the staff page, this page number 40, my lord.
Yes.
Even the staffs has made a representation apart from other issues, even
Number
carry
7.
forward. Number 7, my lord.
Yes.
And thereafter nothing happened. And my lord, page number 42.
Yes.
My lord, he was involving all those the teaching activities. And page number 43. Even the college letter, it indicates a Department of Computer Application. Page number 43.
Yes.
I was asked to, my lord, perform the other courses.
Okay, yes, then.
My lord. Thereafter, my lord, I'll continue page number 45 also. Continue and thereafter, my lord.
Okay.
Page number.
That's immaterial. Yes, come to the
page number
matter.
49, my lord. Page number 49 also.
Yes.
But the staff has to emphasize again his issue.
Okay, that's
Thereafter,
fine.
my lord.
Come to the meat of the matter. Where's your removal?
Then now, my lord, page number 52 onwards. This is important, my lord. Now, this is the letter written by him in the month of October 29. He says that, as per my conversation with today, such and such, I am requesting you to kindly clarify my present status in the college. Because at that time, my lord, there was the rumor going on that the department was, the college management was discussing that the computer application department will be removed from the college. So his service was uncertain. Therefore, he put up this letter requesting the principal. Now, the next page, 53, on 10 December, my lord, another letter,
Okay.
such and such, I'm awaiting your reply. So this is his letter. Now, the next page number 45, on 14 December, my lord,
54,
my lord.
Not 45.
54, I'm sorry. 54, my lord. On 4 December, he put up the letter. And now on 16 December, in the middle, my lord, it was addressed to him, Mr. Dear Arjit Paul, I was of the opinion that you have been informed by the teachers representative of the governing body's decision to do away with the department in the college as it never started as a separate department in the degree section. As of today, the department is not there in the college. So this was issued by the principal. So according to the principal and the management, this is amount to removal. There was no formal removal order also. Removal order. Now thereafter, my lord, we put up the page number 57. Legal notice was issued, but the department did not, management did not respond. Now the
page number,
that is legal notice page number
56.
57, my lord. Legal notice. Detailed legal notice was issued, but the department, the respondent did not answer. Yes. Now, may I take a lordship attention to the short affidavit filed by the respondent college, madam.
What does the college say?
Madam, primarily the college says, madam, the college says that the computer application was never.
Is it maintainable against the college?
Madam?
Is it maintainable?
Well, according to me, it is maintainable. They are performing public duties.
Where's the affidavit? Yes.
Madam, the affidavit, madam. The affidavit, they say that I was never appointed for a regular post. My engagement was a temporary in nature. And number two, my engagement was related to class 11 and 12. Class 11 and 12. And therefore, appointment letter was never issued. And since, my lord, the computer science application was never became a part of the course offered by the school, by the college, the removal from the service is a simplicity in nature. It doesn't require for
Where do you
following
say that?
due process of law. My lord, para 5, Lord, see. Para 5, may take. The affirmative in para 3 and 4 of the writ petitions is vehemently denied by the answering deponent. On contrary, it is stated that petitioner joined the institution as supporting faculty in such 2011 on a temporary basis on a consolidated salary after rupees and such per month. However, no interview was conducted for appointment for the petitioner and appointment letter was never issued to the petitioner. It is pertinent to mention herein that the petitioner had conducted programs on computer literacy in the institution as well as engaged in the classes in higher secondary for which he was remunerated at par with the other teachers. However, the Department of Computer Application was only for higher secondary section, as no permission was accorded from the university to open the Department of Computer Science application for the college. The petitioner initially appointed on a consolidated salary and thereafter bring in parity to pay packages of its staff of the institution. He was placed in the regular college scale of pay, service and such. However, his placement in the pay scale of the petitioner did not alter his service status in the institution as an adjunct faculty assigned with responsibilities only to teach at +2 level classes. It was only on effort made by the institution to treat its employees in non-discriminatory fashion. The petitioner was granted all subsequent pay revision benefits as and when such benefits were extended to the other employees of the institution till the discontinuation of his service. Now, page para 3 also they talk about his service was never regularized. And para 10, my lord. Para 10 also, my lord. It says that the amendment made in paragraph 13 and 14 of the writ petition are admitted to the extent which are borne out of records, and rest are denied by the answering deponent. It is further stated that in the meeting held on such, the GP of the college had decided to do away with the Department of Computer Application in the college, as it never started as a separate department in the degree stage. So this is the basic, my lord, the response made by the college.
What does the law say about this?
My lord, I will come. My contention is that, my lord, department is still in existence.
How do you say that?
My lord.
Yeah, the department never. Their stand is that he's an adjunct faculty. He's just to teach computer applications. That's all. That's why no upon order was never issued. You were never recruited in the prescribed manner. There was no approval sought from the university. We're not teaching graduate courses, you're teaching undergraduate courses. Yes.
We teach now. There are 3 classes of teachers in the college. One is, my lord, the government, the post enjoying the government grant. Well, another is the college sanctioned post.
Yes.
From the fund of the college itself. Well, these are regular teachers. I'm also one of them. And another one is ad hoc or temporary, who are getting, my lord, 500 per class or consolidated amount. Now I fall in the second category, college sanction post. Now the nature of the course offered by the college are 2, my lord. Number 1, my lord, the course that is approved by the NEFU, degree courses. Teachers are there, my lord. And another one, my lord, the courses which is not approved by university, but they are imparting for skill education in the college. And that is, my lord, computer is one. Computer is one. Computer application is one.
The fact remains that it hits at the very base, that there was never an appointment order.
But my lord, therefore
what is the status of a employee who's just has no formal appointment? He's been kept on a regular scale of pay as given to other college teachers.
But
the very basis of his where his service status starts is nowhere.
But my humble submission is that, my lord.
But there's not normally. Your submission was that initially that he has been terminated and removed from service without any due process of law.
Yes.
Now they have not issued any order.
Yes.
There's no termination order.
There's no termination.
There's no proceeding.
Yes, no proceedings. That is one of the ground.
The only said the department exists and you never part of the permanent faculty.
Yes.
Yes.
That is one of the ground. My grievance. Second grievance is there is no ground for doing away with the department because the department is still alive. Now, normally, Lordship is aware, service law, there should be an appointment order. My submission here in this case is that in the absence of formal appointment order, the conduct of the respondent is very vital.
Of course.
If the conduct of the respondent college indicates and show without any doubt that I have been treated as regular, well, formal appointment letter becomes secondary. Now, my rejoinder, I filed a detailed rejoinder. Lordship may take Lordship attention to that.
Yes.
My lord.
And you've been working how many years?
My lord.
How many have you been working?
8 years, my lord. I'm not wrong.
But I've been working there for more than 9 years, my lord.
Yes.
Now, in my reply, my lord, para 5, Para 6, where is it? May I take to my lord, para 6, my lord. Attention. And I'll go to the my lord, the annexures. Para 6, my lord. With regard to the appointment made in para 6 of the affirmative opposition, the answering deponent begged to submit that the college had 3 sets of teachers as stated in para 3 of the writ petition, namely government-sanctioned teachers under the ad hoc grant. Number 2, college-sanctioned post teachers whose salary is duly sanctioned by the college itself. And 3, case faculty or temporary teachers whose salary are also borne by the college itself. The regular college pay scale was only extended to teachers whose service was regularized, and no temporary or part-time teacher enjoyed this scale. Instead, temporary part-time teachers were paid on per class basis or a consolidated salary unless their service was regularized and brought under the regular pay scale, be it government sanctioned or college sanctioned posts. Also, only the regularized teachers were allowed to contribute to the CPF scheme, and no temporary teacher also allowed to contribute.
I understand, Mr. He said all the trappings of a regular appointment are present. The only thing that's absent is the initial appointment order. And so by the conduct of the respondents and by the trappings of employment that he had, which includes the regular scale of pay, contribution to GPF, and also grant of increase in salary, that means that he cannot be disregarded and said that his work is such as adjunct lecturer or something. Yes,
exactly, my lord. My lord, lordship is correct, my lord. Now, the detail of the courses I teach, I have reflected in the rejoinder. I may not take the lordship time further. Now, may I take to the annexures we made, my lord, in that rejoinder, in my rejoinder. Page number, my lord, page number 21. My lord, here may I just highlight one important point is there. Point number 1 in page number 21 of the rejoinder. My lord, number 1, 9 teachers named Mr. Ajit Paul also, my lord. 9 teachers were there, my lord, who did not face any selection process, who were inducted in the service, like writ petitioner. And these 9 teachers, they did not receive any appointment letters. Therefore, they highlighted these grievances to the authority. Subsequently, my lord, out of 9, 2 walk away from the college. 2 walk away, my lord. Okay. They joined to other college. 6, my lord, they received the appointment letters. Like me, my lord, there was no interview. And one of the instances, my lord, page number 23, letter of appointment I have annexed. 23? Page number 23 of the rejoinder, annexure 2. This appointment letter issued to one of the...
Now, annexure 1 is proceedings staff council meeting.
My lord.
What is wrong? What page 23?
Now, page 23, I want to show the appointment letter. Issued
from where 23?
Page number 23 of the rejoinder. 23 rejoinder. Lordship is seeking, looking by rejoinder.
Yes, rejoinder.
Yes, page number 23.
Oh yes, sorry, I'm going by the court page.
This is the true copy. Appointment letter issued to my lord. It says, my lord. Yes. It stated that on the recommendation of selection committee, the governing body, Women's College, is pleased to appoint such as a lecturer in the Department of Political Science with effect from such. My lord, there was no selection committee. He was also appointed like me. But for him, they have issued. And the 6 of them, they received like this. And all of them are holding the college sanction post. Now, they have taken the plea in the affidavit that, my lord, the computer application is not a department in the college. Yes. But admittedly, my lord, the computer application was not recognized by university. NEFU, that is correct. And
can we go there? Can this court go there to discern and to say whether yes, that computer application is a department in the college, and so a mandamus can issue that it should be retained there? No. Or are we looking only at the manner of the method? I mean, this manner of appointment and removal, which is not even a proceeding, which is just an email, which says that that's the only thing you have. What was the situation now? Is still going to work?
My lord.
Are you still going to work or it's over?
Oh, my lord, I'm still willing to work.
No, willing means I'm still going to work.
Yes.
They employ you now or no?
No, they are not employing me.
So after that, you never went back there?
My lord. Okay. And they are giving the charge to one of the staff. Okay, and he is imparting education. Now, why, my lord, I urge lordship to look into the page number 24 onward 25. They have taken the specific plea that the computer application is not part of the department in the college. Whereas, my lord, this document they show they have furnished to the government for accreditation of the college. And they have mentioned, my lord, this is the accreditation page number 24 for the year 2012 and 13. Now, Lordship, you kindly see the department. Faculty, my lord, page number 27. They furnished all this and they got the accreditation from the competent authority for the entire college. Now, faculty, serial number 4, computer application, is very much part of the college. And, my lord, the teacher, faculty staff, my lord, page number 28. See the staff information. Then I will come to the relevant portion, my lord. Computer application is page number 30. Page number 30. And computer application, my lord, the strength of the staff in this department is 1. Page number 30. 1, this is me, in fact. Page number 30, 30. Computer application 301. My lord. Department computer application, they are disclosing the strength of the staff to the authority for accreditation.
Yes.
And number, they say total 1. So 1 person is there. This is
That's
the
you.
petitioner. Yes.
How do you know that's you?
My lord, this is, no one is there other than me, my lord.
Okay.
This is my respected submission. And thereafter, my lord, another page number 43. Lordship, can you see? Is also
Yes,
there.
there is only a survey in higher education.
Yes, yes. And because of this particular furnishing the authority has given the accreditation, my lord. So they want to establish in that way. Page number 43.
43.
43, my lord. For the year 2014-15, same thing. Then I may go to my lord, page number 46 to save lordship time. Straight away to the
46?
department. 46, no. 46, relevant portion. 46, my lord. This is department, the program offered by the college. Serial number, my lord, 11, that is page number 47, computer application. And staff information also, my lord, will continue, and it is available in page number
48.
My lord, my lord, 53, my lord, staff application is available in page number 53. They have mentioned 1, that is the writ petitioner. Similarly, my lord, again, with lordship permission, page number 62A for the year 2015-16. 16, my lord. Page number, relevant page number, my lord, page number 52D and E, my lord. The program offered by the college.
52?
52D and E, my lord. Page number. So 62, I'm sorry, 62. 62D and E. Serial number 10, computer application.
Yes.
In staff information, they disclose the same thing. Page number. Page number 62. J and K. 62K, it is available. So all throughout, my lord, computer application is part of the program offered by the college. And now, my lord, may I take lordship attention to page number 63. This is the syllabus, my lord, offered by the college even now, 2004.
62P.
63, my lord, 63, my lord. Certificate course in office automation is a computer classes, my lord. Page 63. Eligibility pass class 10 and 12. So this is offered to the degree students also. These certificate courses. This is still continue. And the last one may I take, my lord. another page number 73. May I take Lordship? 73. This letter was written in 2010 to the university by the college. They disclosed that, yes, 2007 they sought permission from the NEHU to allow them to open the computer application as one of the recognized courses in this college. But the university turned down that one. Therefore, they requested to support the university to the college. Now, madam, page number, my lord, may I come? Even the writ petitioner, page number 75, on the instruction of the college authorities, they form a two-member committee to formulate the syllabus for PCA. Page number 75. And writ petitioner are that they have even formulated the, my lord, the courses.
No, don't do it anyway.
My lord, I'll just pass through, my lord. The last one may I take. Now they have taken the plea. They have taken the plea that the computer is no longer education is offered in the university, in the college. This is contrary to the record. Now the last page number 83, Annexure 9. This is the prospectus for the academic year 2022. Page number 83. 83.
83 of?
83 of the rejoinder.
You skipped from rejoinder?
Rejoinder.
Yes, okay.
83.
Okay. Anything else?
Now, this is the last annexure I want to show, my lord.
83?
83. Now, this is the prospectus for the college. Now, may I come to the relevant portion? Now, what they have done, instead of mentioning, my lord, computer application in the college, they have changed the nomenclature, different nomenclature, and they are still imparting. Lordship, kindly see page number 94.
No, because they did not get permission from NEHU to run computer applications.
My lord, if the, my lord, the...
What's the permission from NEHU?
NEHU is a former party. Well, we have to copy. Now, Lordship has put that important question. If the university NEHU allow, this will be a full degree course. My lord, without allowing by NEHU, that doesn't mean that they cannot impart computer education.
Yes.
Now, page number 94. It says they claim, my lord. May I read, my lord? National Education Policy 2020 focuses on skill development programs, wherein it supports beginners by bringing innovative skills and technologies to the community for better quality of lifestyle and livelihood, and which in the long run would create sustainable and visible social impact. These programs emphasize on stimulating a scientific outlook among members of the community and develop scientific attitude, curiosity, and capability to experiment and adopt new skills and innovation to improve.
Right.
Now,
where is it in computers?
Now, number 2, my lord.
Go to your website.
Go to your website. This is absolutely, my lord, the entire computer education is imparting. They only change, instead of computer application, they go to your website. Teachers are there, my lord, temporary teachers are there, students are enrolling, and they are receiving 6-month courses every year. And many students are enrolling in this course and obtaining the certificate courses. My lord. Earlier, my lord, petitioner was asked to teach all this.
What authorities do you have?
What?
Authorities in law.
My lord, today
Yes, very short, a very short compass. Only that you don't have one order, you are treated as a regular employee for practical purposes, and certainly there's no specific removal order, there's no specific appointment order. Only that is basically discontinued. You're just adjunct kind of faculty, which was recruited at that point. Right. But to be fair to you, they give you regular pay of scale, college sanction pay. That's it, and there's no post as such. You only were there to help, and you did not teach in the graduate. You taught me undergraduates. That's all.
But only one aspect, my lord. The teachers who are teaching in the degree level, they are also allowed to teach in the class 11.
No, that is immaterial. Only thing is that now we have to the status of your appointment, and whether on the basis of only thing is that you have to say that circumstantially or notionally that you have should be given the status of a regular employee. And the other part which we court cannot touch is this discontinuance of the department. Whether how can the mandamus issue to say that he should be taken back to service and the department should be restarted? That is up to the college.
My lord, if the department is no more there, my lord, I have no right to pray.
No more there, then what are you going to do?
My lord, I have no right to pray, my lord, before lordship. to direct the department, college to create a department for my sake. It is not. My humble submission is that, my lord, department is still in existence.
Did the state file affidavit?
They did not file.
Why? What kind of pervasive control do you have over this college? Why?
Petitioner is seeking no relief from the state.
Because no relief. What is the kind of what kind of is this? Is this it's affiliated to Nehu, correct?
Yes.
And you have some sanction posts.
Yes.
You're giving them some aid, correct? Deficit. Is it deficit college? How many posts are you paying for? Yes, but Chanda.
But then, my lord, it is obvious that probably petitioner is not. Post, my lord, as against which the petitioner here, I mean, they are saying that it is a college sanctioned post and it is the funds are paid by the college, my lord. So that is why, my lord, they are not.
No, what this court wants to know is this: whether he was at any point of time appointed against a post which is a state, which is given by the education department. There'll be a certain number of posts which are paid, salaries paid by the state government, correct?
Yes,
and then there's a number of posts which the college on its own, by its own resources, pay, correct? So you are saying that the state, he was never under any sanctioned post, sanctioned post by the state.
My lord.
He was on a college post only.
College post, and the funds are his salaries are paid by the college administration from their funds, my lord. So it is not from the state, my lord.
So is it a fact that this department is discontinued?
My lord.
There's no computers at all in this, what's this? Women's college?
No, my lord. What had happened is, my lord, in the year 2019, there was bifurcation of the HS section and the degree section, my lord, as per the instruction of the MOs, my lord. Thereafter, my lord, it was higher secondary section and college section was managed by different types of management, my lord. And initially, when he was appointed, my lord, he was appointed in HS section, higher secondary section, 10+2, my lord. But he was rendering services on add-on courses, and for which, my lord, he was adequately remunerated, my lord.
No, but the thing is that, Mr. Chana, see, what troubles this court is that this poor fellow has been working since 2011.
My lord.
And for all purposes, you have been treating him like a regular employee.
My lord, his appointment...
What is the duties of a model employer? His service, that means you just have to, it's just like you just throw him out, that's all.
My lord, we have not thrown him out, my lord, because we have given him, my lord, we have told them that since this two department has been bifurcated, my lord, so we have allowed him to serve in the HS section, my lord, to which he did not agree, my lord. In fact, my lord, we have given him post in library also as library officer, my lord, to which he did not agree, my lord. He insisted that let there be a department of computer science be opened in the degree section and
let me be in charge of it.
Let me be in charge of that, my lord.
So what are you doing now? He's not doing any work.
My lord, he's unemployed, my lord. He's unemployed.
The computer guy is never unemployed. Anyway, yes.
Even if, my lord, what I'm saying, my lord, even if, my lord, any order flows from this court, my lord, we won't be in a position, my lord, to accommodate him because there is no
the court understands that also. That is why we can't interfere into, like what's your whatever policy decision you have with regard whether a writ is maintainable at all against women's college. Have you taken that point?
My lord,
is the writ maintainable?
My lord, that is one of the ground, my lord, because under Article 12, whether we come into that...
It might not be under Article 12, but it might be amenable to writ jurisdiction when it comes to service, even how you're treating the employees. Where have you made an affidavit and maintainability? You have made any points?
No, my lord.
Then? But you can argue maintainability. There's no hard and fast rule that says you can't. But
and also, my lord, in terms of the pay, my lord, that he was being given, my lord, it was, my lord, at par with the other similarly situated employees, my lord. He's saying that he was placed under regular pay scale and that is why he's being regularized, my lord. That is totally incorrect, my lord. My lord, on that aspect, my lord, Jagjit Singh is very clear, my lord. My lord, even temporary employees who are doing similar nature of duties, my lord, they are equally entitled to receive equal amount of pay.
Let's not go there. It's just that it's very strange with regard to how the manner of engagement of the petitioner. Any other faculty also engaged the same way in the college? Or he's the only odd man out?
He is the my lord.
Odd man out?
No, my lord. He was appointed initially on verbal, my lord, terms, and on temporary basis, my lord. There was no selection.
How can you see verbal terms and can see anything? Temporary basis, but the thing is that is very strange. You use his services for, and then there's no proper, even there's no severance or something. There was not even a contract signed.
No, my lord.
Nothing.
Nothing, my lord.
On verbal, on a handshake, you start working. Strange case. So you have any authorities, Mr. Changresa, to show that you have acquired a vested right to continue in a certain post in the absence of any.
But today I'm not with those citation. If Lordship give me 2 weeks time, I'll try to do some research.
Then why did we enter the hearing that 2 weeks time will be given?
But otherwise, my lord, my humble submission is that by virtue of the conduct of the respondent, they cannot dispute my status.
It's not a question of conduct. It's a question of your entire the origin of your service springs from where.
And my friend has pointed out that I'm the only one.
You said that there was no hearing removed. Now, where's the question of hearing? Where's the question of you never appointed?
Well, that is the content of the.
It's like you were a voluntary worker who went and served in some organization where you paid some remuneration, an honorarium they call it.
They cannot take that plea anymore. The moment they give me the permanent regular skills. Admitted, there is a great distinction between the temporary and the teachers holding the college sanction post. They never dispute that one. And my friend has pointed out I was off for library.
We're trying to give time because let's do some, because this is very strange and we cannot ignore the fact that you served for how many years?
8 years.
More than 9 years.
2011 to 2019, my lord.
You didn't represent before the government?
No, representation, no, man.
In fact, they have alternative remedy, my lord, if I may point out, my lord, which they have not availed, and my lord, they have come.
Under the college teachers' rule?
Yes, my lord.
You can go, any position of governing body, anything you have recourse to. You have recourse to.
My lord.
Yes, you have recourse to appeal. You're aware of that, no?
Well, he did not appeal.
There's a judgment from this bench itself.
Well, I was there.
That you were there in the case?
I was there, one of the cases.
What case was that?
That is the Senate's case.
Jefferson
case. Recently.
Yes.
Jefferson case.
Well,
that's gone on appeal?
My lord, I don't think so, my lord. I'm not aware. I don't think so. They did not go for appeal. Lord, give me 2 weeks time, if my lord.
Because if there's any kind of oppressive action by a governing body, then it will go before the what do you call it? What is the authority? It's we are aware of that. Yes. Yeah, that case you've seen that case Jefferson.
Jefferson cases.
Yes. When was the judgment given? 1 month ago? 2 months ago?
2 months ago.
16 months.
2 months ago. 2 months ago.
Yes.
Lordship may keep it as a part heard and allow us 2 weeks time.
You won't go to any other bench, so why you been part heard? How many judges do you see in this big courthouse? In the course of hearing, the senior counsel prays will have some time to seek out authorities in support of his case. Just after 2 weeks, yes.
Yes.
Next matter.
I know.
35.
Appellant, Your Lordship. This is the appeal against the succession granted by the judge, the council court.
As the records come, I think we'll need
paperwork also has been prepared and
where's the paperwork?
The matter has been heard at once also, Your Lordship.
By whom?
By Your Lordship. Your Lordship. Where submission was made the bar, for settlement, but settlement failed, and that's why we're here again.
Where's the respondent?
Well, it's not been appearing, Your Lordship.
Who's the respondent?
Mr. C.H. Maulam.
His juniors appear. Where's the last one? Sorry. Who's M. Marwan? Who appeared last time? Oh yes. In April talks at field.
Yes, Lord.
When Mr. A.R. Prasad present behalf of the appellants, none appears on behalf of the respondents today. Stop. in interest of justice, this matter after.
Lordship, maybe 1 week, Lordship.
Let's say after 2 weeks.
Obliged.
36.
Motion again. Yes. What is 185 of 2022?
Connected matter, Your Lordship.
Yes, what is the matter about?
The NIT trainee teachers.
Where's Mr. Gautam?
It's out of station, Your Lordship.
You'll take up the matter?
I don't think I can, Your Lordship.
Why you don't think you can?
No, Your Lordship, they ask, Your Lordship, because we are not aware, Your Lordship, if the director has been appointed or not.
Has the director been appointed?
Not yet.
We've been waiting on that.
What to do, Dr. Mazika?
Interim protection is there, my lord.
Yes, interim protection is there. This is matter due to the absence of Mr. K.S.H. Gautam. This is a matter after 2 weeks. It's also Dr. N. Mazika is also Dr. Praise allowed to take further instructions in the matter. Just accordingly and so on.
The interim order to continue.
Interim order shall. It's until further orders, I think. No? This is the last one.
Your Lordship, it is dated the 3rd of June 2022. It's only to be...
Till the next date.
Your Lordship?
It's set till the next date.
Yes, Your Lordship. It continues.
The two matters are listed in item number 44, my lord, which is a connected matter. The interim order is until further orders.
Yeah, until the further orders is given here. It's not. Yes.
Second call, supplementary list, item number 1.
Look here. Huh? Ah. Yes. Yes, Mr. Chariso.
My lord, only my prayer, my lord, during this interregnum.
Where's the prayer?
My prayer, my lord.
Why do you find
they
a
approach
petition?
the gate, my lord.
There is different cause of action, correct?
The impute.
A different cause of action.
Different cause of action.
Then?
The only prayer, my lord. Lordship, can you see page number 14 of my petition, my lord. Issue an appropriate writ or direction by this directing respondent not to give effect.
Any instructions you received, Dr. Mazika?
No, I tried to inquire if CAT is closed, my lord. This is the fact, my lord.
Right,
My lord, from the department, the instruction is that now, because here what happened, my lord, there are commissioners all over the country, commissionerates of the GST and customs, my lord. So earlier, these grades of employees were transferred within the commissionerate, my lord. So Shillong is one commissionerate, my lord, northeast, so they'll remain within northeast. These people were appointed, one is in Delhi commissionerate, my lord, one in Kolkata, one in Chennai, the petitioners here, and they are on transfer to Shillong zone, my lord, from their parent department, my lord. Now a decision has been taken because, and this decision, it appears, is on their persistence only, that because what is happening, it is a counter effect also, my lord. The people from northeast have to be sent to Chennai and Kolkata and Bangalore, my lord. So to rationalize all those things, again a decision will be taken that intercommissionary transfer will not be given effect to, my lord. Now this is a now flip side also, my lord. Those who are beneficiary of this, my lord, the intercommissionary transfer.
It's a policy decision, correct?
It's a policy decision.
And the thing is that appointment to for these commissioners or a parent what do you call it?
Parent cadre.
Parent cadre.
Parent commissionerate.
Parent, yes. Now, so appointments, suppose you apply from Chennai, you get appointed from Chennai.
Yes. Because it seems that area-wise vacancies are notified, my lord.
Is that all India kind of situation, your seniority?
But it is
Severity
different.
may be, my lord, but the transfer, my lord.
Even if,
Because they
that
are-
is the situation, if notice all India, even transferable throughout India.
My lord, the scheme it appears, my lord, up to certain level, my lord, B, C, and D grade employees, my lord, they are not sent too far, my lord. But when they move to grade 1, then all India transfer liability comes.
Okay, take down then. The writ petitioners are before this court being aggrieved with the, you said the reversion order, correct?
Repatriation order.
Repatriation order.
Repatriation order, sorry. With the impugned repatriation order dated
28/6/2023.
dated 28/6/2023, whereby whereby they are to be relieved of their
Yes.
present duty, relieved of
Present.
the duties and present posting, and to report back to the
Parent zone.
to the parent
Parent zone.
Parent zones.
to the parent zone. Stop. Next parameter, Mr. H.L. Changres, who is a counsel assisted by M.S. Wanyang, for the petition submit that the writ petitioners have been compelled to come before this court by way of this application under Article 226 to assail the impugned order of repatriation in view of the fact that the Central Administrative Tribunal at Guwahati is closed for the summer vacations, and is due to reopen on
27 July 2023.
on 27/7.
So I'm sorry, 17 July.
On
17.
on 17/7/2023. Stop. The limited prayer as made out in the by the writ petitioners is only for a status quo till to enable them to approach the Self-Administrative Tribunal on its reopening. Next paragraph. Dr. N. Mozika, learned DSGI with so and so, concurs to the submission of the Learned Senior Counsel of the Learned Counsel for the petitioner that the CAT is presently closed and reopen after the vacation of 17 July 2023. Stop. Next paragraph. In view of these submissions and without entering to the merits of the case, stop. This court directs that status quo as to the movement of the petitioners shall be maintained until 17 July.
But if Lordship do not mention the particular date, until the reopening, my lord.
Until the reopening of the Self-Administrative Tribunal after the vacation, after the current vacations. Stop. No, it has to be specific date because then.
The reopening day, hopefully, my lord, prior to that, we may be allowed to file application.
But what I've been told that they can still file in Calcutta bench.
They can file, it's no vacations, but then it'll be mixed up because we know how that works. We have to be online, they have to be virtual. No thought on the last.
In view of this submission and without entering into the merits of the case, this court directs that status quo as to the movement of the petitioners shall be maintained until the reopening of the CAT after the current
CAT on 17 July 2028 to enable them to seek appropriate remedy. Stop. With the above direction, reparation accordingly stands disposed of.
Meanless 40.
In view of this order, you can move it unlisted on that date.
Well, they should try that.
Yes, of course.
Well, I know.
17th shows something in red melon.
Yes.
17th July shows some.
17 July is a local holiday here.
It's holiday here in house.
Unless Tirat Singh is recognized in Assam also.
In item number 40, my lord, my learned senior Mr. Paul is appearing, my lord. I'm praying for some time, my lord. 1 week.
You're for the petitioner?
Well,
You're paying for the MHRC?
Lordship.
Mr. Shulai?
For a stay, your lordship.
5 to 7. What to do? You don't have any urgency in the matter? Yes, appraised me on behalf of Mr. Kepo, also to be not in station for accommodation. This is matter after, let her write the date. On so and so.
Obliged.
42.
Please, Your Lordship. Also, I put on matter maybe adjourned for the Lordship.
For?
For the day, Lordship.
You are appearing here, Mr. Corona?
Yes, Lordship.
Yes, you are the leading counsel. Yes. The only counsel in fact.
Lordship, the leading counsel.
So you must be eminently prepared.
Lordship, the arguing counsel is the WAG Lordship, Mr. Khalid Khan.
Double AG? Double AG means what?
Of the advocate, additional advocate general Lordship.
Oh.
Sorry, my apologies.
Twice AG that means.
Lordship.
But Mr. Khalid Khan argues in criminal matters, correct?
Pardon?
He's your criminal AAG. And Mr. Shulai is your civil AAG. Or what? Is that how its work is given?
Lordship, but Lordship has been matters I endorse according to the Advocate General's.
Prayers made on behalf of the who Mr. Khalid Khan was not in court today. He's in there in division bench.
Lordship, we were preparing for I think the matters before division bench, Lordship. At the
For tomorrow.
Lordship.
Yes. Advocate General's not in town?
Lordship, he'll be landing today, Lordship. Tomorrow's a full bench matter.
That's on the request of so and so. This is matter.
I'll oblige.